judge denying the state's motion to stay his ruling against Illinois' prohibition for carrying concealed firearms on mass transit, while also not sanctioning the attorneys that wrote a controversial sentence in their motion for that stay. I was able to tune into this hearing yesterday, and we're going to review all of that here with Illinois in Focus Daily. I'm Greg Bishop. Be sure to like, subscribe, hit that notification bell with America's Talking Network, and join us each and every weekday morning as we go live with multiple stories each and every weekday morning at about 8 o'clock here with America's Talking Network. But if you go to thecentersquare.com, where I'm the associate editor, you'll be able to see the story about the federal district judge denying the state's motion to hold his ruling against the prohibition of concealed carry on mass transit. This case filed back in 2022. You have 4 plaintiffs involved, and on the briefings that were filed, the judge ultimately made a ruling that it violates the Second Amendment to prohibit individuals who have concealed carry licenses in the state of Illinois from carrying their concealed firearms on mass transit. So when that ruling was issued in late September, you had the state say that they were going to appeal, but they also wanted to hold the judge's ruling, which only impacts the plaintiffs. And I think that's important here. It's not a ruling for the entire state, for all concealed carry license holders to be able to carry their firearms concealed lawfully on a public transit, but just for these 4 individuals. So the judge made this ruling for these 4 individuals as it goes to the appeals court. You have the State Rifle Association saying that they hope to expand it in the appeals court to allow for this to have impact on everybody. But in that filing that the state made against this ruling, trying to say, hold the ruling because there's the possibility of irreparable harm, because this could allow for people to have firearms on mass transit. And the sentence that they wrote in their filing caught the judge's attention when they said something to the effect of that 3 days after the judge's ruling, there was a quadruple homicide on the CTA Blue Line from somebody who carried a firearm on the train. So the judge read that and demanded that the attorneys that wrote this in defense of the law answer to questions, and that hearing was yesterday. So I was able to tune into it and break down. We'll go through all of this here with you with Bishop on air from X. So watch this. The hearing started. Case has been called. Appearances of litigants announced. You had David Siegel for the plaintiffs, and the defense included attorneys from the Illinois Attorney General's office and the Cook County State's Attorney's office. The judge says the focus of the hearing is something that he didn't think would be a big issue, but it has turned into one. Looks at the state defendant's motion to stay the ruling pending appeal. Says the filing says public interest favors stay of appeal. Judge focuses on public interest overwhelmingly favors the state. Further, in contexts of public interest, moreover, the potential safety implications of the court's order are highlighted by the recent mass shooting on the CTA's Blue Line, in which 4 people were murdered with firearms 3 days after the court's order was entered. The hearing went on with the courts discussing how does the court's order impact public safety. Judge Iain Johnston says that he'll be reading from the letter because there was a recent mass shooting on the Blue Line in which 4 people were murdered 3 days after the court's order. Johnston says the only reasonable interpretation of that sentence is that, Judge, your order killed 4 people. You're all lawyers, he said. You all understand causation, he said. He says that timing could be something used for causation. Not sure any other purpose of adding 3 days into that sentence. That's what I interpret, he said, to be the only reasonable interpretation of the sentence. And he mentions the state's filing in response, saying that it was sort of a non-apology apology. Hey, Judge, we're sorry. Goes on to ask the litigants to explain why it's not interpreted to say that the court's order caused the mass shooting on the Blue Line in Chicago. The Attorney General's lawyer said that the intent of the sentence was not to suggest that the reading of the court, there are, from our perspective, 2 critical words there. One, no potential causality was intended. There are potential safety implications that we found on measures that relax firearms regulations. But then the judge interjected and said, did those articles cited by the attorneys for the state ever relate to a court order finding of an individual who possessed concealed carry license caused murder? Right? And I think that's a distinction that the judge was really wanting to get after here is that that he asked for the lawyers to come in and prove if they did a reasonable inquiry into whether the assailant in that Blue Line murder had a concealed carry license and whether he was doing that in self-defense. So when they cite articles about, relaxed firearm regulations leading to more shootings, the judge interjected and said, did any of those articles cite a court order finding an individual who possessed a concealed carry license caused a murder? The attorney for the Attorney General's office tried to explain, but the judge asks his question again. The attorney says, not aware they are specifically related. So the attorney says that some do pertain to concealed carry holders from the studies he cited and the stories he cited. The judge asked how, and the attorney said that taking them in order, right to carry laws and violent crime article, with a finding that the right to carry laws can lead to increased violent crime. Again, this is something that the attorney for the state is pointing out, but the judge interjects, was it causal or just related? Opinion of authors that causal connection could be drawn. The judge firing back could be drawn. Not that they did draw. And then the attorney responds, they did draw a conclusion about what the data could show. The judge asks about the word could. And the attorney says that those involved in the study were statisticians. The judge saying, stop. You're familiar with standard deviations. And then they have a conversation about standard deviations and causal connections and regression and statistical analysis. But then you've got the quote here, why didn't you put any of those things instead of citing the Sun-Times? You said that there's been a murder on the Blue Line 3 days after your order. In the motion for a stay, it was just to highlight one example of the result of relaxed firearms regulations, the attorney said. Judge reviewing the sentence again, relaxation of firearms regulations would have been my order. And the result is 4 people killed on the Blue Line is what the judge interpreted that is. The attorney said that's not correct. Excuse me. I just read it. Want me to read it again? The judge said, focus now on the word highlight. Why does the word somehow magically change the meaning of the sentence? The judge asked. The attorney said that he hoped to make it clear. And didn't make it clear, did it? The judge responded. Meant to highlight the kind of harm that could occur with relaxed firearms regulations at a high level, the attorney said. The judge said that sentence implies that order led to people being murdered. The attorney responded they wanted to highlight the potential safety concerns as a result of the stay on the judge's order that the ban on concealed firearms on mass transit is a violation of the Second Amendment. The judge responding, I don't want to kill 4 people. I don't want to kill anybody. The attorney said they cited the shooting as an extreme type of harm that can result from firearms, and it was an example in an attempt to connect. And then the judge interjects the court's order. No, the safety implications, the judge says, of the court's order. When you keep saying could, that this court order could implicate the mass murder of sleeping homeless people, why is that not speculative, the judge said. Explain could. Then they talked about the word could, and now the attorney says he didn't write that in there. But the judge says you said it 5 times during this hearing. There's a good reason to believe that relaxing firearms regulations could lead to potential safety concerns, the attorney says. Then the Cook County State's attorney's lawyer speaks in and says that they don't think that there was any kind of inference in the sentence at question. We read the sentence differently, the attorney said. Not to say this court's order was related to this incident, but it's very much top of mind for public safety and the public interest. We certainly were not suggesting that the court's order was related to the Blue Line incident, the attorney said. Then the judge goes back and forth with a ton of questions. Did the court order kill 4 people? No. Did the court's order kill anybody? No, Your Honor. Did the court's order lead to any people shot on mass transit in Illinois? Not to our knowledge, the attorney says. The attorney then mentions another shooting in the Red Line that happened yesterday morning, and the judge asking any evidence the court's order caused that shooting on the Red Line. The attorney said they didn't have enough information. Another said that they are never inferring that the court's order was the cause of any shooting. The discussion about concealed carry and the law that passed, how many prosecutions of people with concealed carry licenses carrying handguns on public transit have occurred since 2014, the judge asked. The lawyers didn't have any information on that. He says he's just getting facts on the motion to stay because he said that it was a fact-free motion. And he asked the Cook County State's Attorney's lawyer the same question, and they didn't have any info on that. The judge then asks how many arrests have been made of CCL holders with guns on mass transit. Any evidence they accidentally discharged a firearm on public transit since 2014? Shooting anybody since 2014? The state's lawyer says it's up until court's order it was illegal to carry. People violate the law all the time, the judge said. Keeps him busy. Do you have any evidence of the CCL holder shooting anybody on mass transit? The state's lawyer doesn't have any info on that. And this is about law-abiding citizens, right? Yes. Any evidence that they are criminals? Not aware. Any evidence someone CCL revoked because of their bringing a gun on mass transit? They didn't have any info on that. Have you guys prosecuted any CCL for bringing a gun on public transportation? No one spoke. It was silence. Must be no, the judge said. To obtain a CCL, the applicant must be qualified. Can we agree on that? The judge said. Yes, they must fill out a form and provide materials to fulfill requirements. Illinois State Police is responsible for issuing CCL after application and investigation, correct? Yes, Your Honor. The judge then says part of the qualifications, 21 years old, valid FOID, can't be convicted or found guilty of certain crimes, not subject to pending arrest or other disqualifiers, can't have been treated for various addictions, right? Hearing no objections, I think everyone agrees, the judge says. Applicants must complete firearms training and must be certified by a certified firearms instructor. Can we agree on that? Then says he's willing to give the statute to the attorneys, but a lot of crosstalk after that. And somebody had their microphone open on the phone, and they were talking about how they need a ladder. It was kind of interesting. Cook County attorney then says they agree with the statute and don't take issue with the various points that were brought up. The judge then says he's trying to get evidence where the motion was devoid of evidence. So he continues to go through other CCL requirements, including the renewal periods. Any evidence that any of these plaintiffs in the case, again, 4 plaintiffs in the case, did not complete firearms training, any evidence that the firearms instructor for the plaintiffs was not properly certified, any evidence that the 4 plaintiffs were not found by ISP to be qualified to have a CCL. Can we all agree that the director of the Department of State Police is appointed by the governor? Anyone to doubt the competency of the ISP director to conduct the operations, including the CCL? The attorneys replied no. Then the judge says the governor could remove the director if there were concerns, right? And the judge asks, and takes no objection as a yes. I'm not aware of the governor's thoughts on ISP director one way or the other, the attorney said. The judge then discussed the ISP must find the CCL applicant does not pose a danger to themselves or others. The attorney agrees that such criteria must be met. Any evidence they're not fulfilling that mission? Not that we're aware of, the attorney said. Then Mission of Concealed Carry Act that no CCL is issued if someone's a threat to public safety. Cook County's attorney said that despite the goal of ISP, it could have an effect into it could have imperfect information before granting a license. Then the judge says any evidence of that. And then the attorney said, I think the Concealed Carry Act provides limitations on issuance if someone is determined to be a threat but not aware if they can make the determination that they could be a threat in the future. Later, she said that if they are a threat, a license could be revoked. Any 4 plaintiffs found to be danger to themselves or others? At time of issuance, no evidence, the attorney says. The judge then said there's a lot of discovery in the case, and surely the state and the Cook County attorneys investigated the plaintiffs thoroughly. Anything in there that would show that they were a threat to public safety? Nobody spoke. I'll take that as a no. Any evidence the 4 plaintiffs had any objection from any law enforcement agency? Not to our knowledge, the attorney said. You guys are the state with resources to investigate. Any evidence? Not aware of any. Then they talk about the CCL review board with 7 members, and they review objections by law enforcement agencies for CCL holders. The CCL board members are appointed by the governor. Any evidence the governor expressed concern about the competency, diligence of the review board doing their job? Can we agree that if there was a concern that a board member not doing their job properly could be removed? No one objected. Can we agree that it's important that the members of the review board were qualified, diligent, smart, etc.? Then they discussed the chair of the board, Donald Wilkerson, as a former magistrate, someone who fits those characteristics needed, Judge Johnston said. Motion then mentions other members of the board and asks if for any reason they can't do their job, any concerns about anybody on the review board not able to do their job. No one speaks up. Is that a no? The judge said. Are they still on the line? Because nobody was speaking up. So then you had some people speak up and said they have no disagreement with what the court said. Any reason to doubt that the 4 plaintiffs in this case were not properly licensed CCL holders? No. Any reason to believe the 4 plaintiffs in the case are a danger to himself, herself, or others? No. any reason to believe that they are a danger to public safety. The state's lawyer says that a study shows increased firearm carrying increases shootings and says it was an expert report shared by Cook County. Cook County attorney said that's with regard to the reports, it's the opinion that anyone with a firearm discharging a firearm in close proximity of a train could hit a bystander in general, not specific to the plaintiffs. But then the judge asks, what about those who are trained? The attorney said the study's outcome was in general. So his view is that everybody is a public danger that's carrying a firearm, the judge said. Our review of plaintiffs did not reveal any specific training of discharging a firearm in a close-moving vehicle. The judge then asked if evidence was gathered about plaintiffs' ability to handle firearms, and did defense experts conclude anything. The attorney said that their experts did get depositions of the plaintiffs and other evidence, and his opinion didn't apply to the plaintiffs. He reviewed the info of the plaintiffs, but the evidence didn't alter or sway his opinion in one way or the other that they had the training to discharge a moving closed vehicle. So anyone carrying a gun is a public danger. That's what the judge asked. And then the attorney cites a story out of New York State. One example, good for all, the judge responded, and he just told them to stop. Then the judge discusses the motion to stay or hold that ruling pending appeal. There's no class action. He says, I didn't issue a broad sweeping judgment. It was focused on two sets of people for two sets of public transportation. Granting a stay is very discretionary. Then the judge talked about, the different types of conclusions that judges come to with these types of stay requests. It's an extraordinary position to grant a stay. The purpose is to relieve the losing party from changing behavior. He talks more about how to determine if a stay is warranted, likely to succeed on appeal, and irreparable harm are a couple of the standards. Then the judge reflects on appeals judges' thinkings on the standards. And the irreparable harm standard he focused in on. Harm cannot be speculative or theoretical. Quote, you can't speculate that just because I'm allowing 4 specific plaintiffs to carry handguns for self-defense that all hell's going to break loose. That's a direct quote from the judge. There's not certainty or immediacy of certain harm, he said. And he mentions a footnote of a news article of people saying that they're going to bring their CCL on public transit, and says it's not good to get legal advice from newspapers. And he mentioned the Fourth Estate's important, but he said it's not a good idea to get legal advice from newspapers. And he says even the plaintiff's attorney, when we talked to David Siegel here with Illinois in Focus Daily, he specifically said, don't, wait further, get legal advice. But the judge says that there hasn't been any evidence of any CCL holder carrying concealed weapons onto public transit, and there's no immediacy, no certainty, no evidence, no affidavit from anybody about arrests, no affidavit from the chief of police of Metra. He says you don't even really see police on Metra. And he continues, I've been presented with no evidence. This is an evidence-free motion. He says they just don't like his ruling. A lot of people don't like my ruling, the judge said. No arguments have been presented to me other than we think this is constitutional and we stand by it. The Second Amendment, like other rights, the judge said, is the Constitution is personal, protects people, not places. The Second Amendment's a personal right. It's not all-encompassing, he said. There are limits, as the Supreme Court of the United States laid out in Heller and Bruin, in limiting certain places. But the judge, just thinking the judge is wrong isn't good enough, he said. So he says, my order again was not some far-ranging judicial activism, just review what was brought to me. The case was about the 4 plaintiffs wanting to exercise their Second Amendment rights. And he talks about his ruling being characterized as unsettled by the appeals court. He says he would like more clarity from the Supreme Court of the United States about all this, but the federal judge says the first 2 elements of granting a stay have not been met, and the expressed important value of people being able to exercise their rights. And he says after going through all the detail on how to obtain a CCL, there's zero evidence that these 4 plaintiffs are not properly licensed, zero evidence they threaten public safety themselves or others, no evidence they didn't go through the training, that their instructors weren't qualified. He says, I'm not seeing harm to the public, and the fact that some lunatic murdered allegedly sleeping homeless people doesn't carry the day at all. He goes on to say it doesn't even come close to meeting the burden. Don't see the harm of people exercising their constitutional rights. Judge Johnston, federal judge in the Northern District of Illinois, says he's confident in Illinois State Police and the CCL Review Board that they are going to do their job correctly, and if they thought there were a problem, they would be removed or somebody would have their license revoked. The argument that the balance weighs in favor of the defendant because plaintiffs don't ride transportation much, that was an argument that was made. That cuts both ways, the judge said. If they don't ride much, then they won't light the place up. Maybe they don't ride much because they want to carry their concealed firearm. Lack of evidence that the defendants bear to establish the public safety concerns not met. Then he says the motion to stay is denied. He says no sanctions being issued on the lawyers as they had this pretty lengthy conversation, and no sanctions. But he said that they're to be held to a higher standard. Quote, this isn't a Facebook post. This is already a highly charged issue. We don't need to increase it with allegations of mass murder in connection with a court order. That doesn't help anybody. And then that's all. The court is adjourned. So fascinating, conversation there with the attorneys for the state and also for the Cook County, getting some verbal lashings from the judge. So if you missed that, listen, I encourage you to follow me on X because we'll be doing a lot more of these as the cases continue to not just focus on concealed carry, but a whole host of other things as well. Just a note, I have yet to get any info from Illinois State Police about a new list of banned guns, and we're still waiting for any outcome from the Southern District on the gun ban. Expect that in, about 2-3 weeks or so. We'll obviously be tracking all of that here. With Illinois in Focus Daily, like, subscribe, hit that notification bell, and join us each and every weekday morning for Illinois in Focus Daily with America's Talking Network.